Well, we've seen that the use of force is in the news quite a bit at the moment because of that police officer, but it's also an interesting subject generally. So what I thought I'd do is I'd just do a little introduction into the law regarding self-defence and defence of another. Just to give you by way of background, I actually used to do a bit of lecturing for the armed police, so I'll be sort of digging out some of my old notes on that. But what is the law? Well, basically, the law recognises that it says it's a matter of good law and good sense that a person who is under attack, or if somebody else is under attack, then you can do what is reasonable, proportional and necessary to defend against that attack or to prevent somebody else being attacked. But what's the test? It's a two-part test. First of all, what is the threat as you perceive it? Now, interestingly, it's different for criminal law and civil law. For criminal law, it's just what did you honestly believe the threat was. Now, that can be a mistaken belief, okay? But it doesn't even have to be a reasonable belief for criminal law. That is different, however, for civil law. For civil law, it also has to be a reasonable belief. So you might be acquitted in a criminal court if you defend yourself, but you could still face a suit in the civil courts. But also, a lot of disciplinary bodies, like for instance the police disciplinaries, they now apply the civil test in disciplinary proceedings. But once you've established that, then that's the subjective element. What did you think? But then it becomes an objective thing. What would a reasonable person facing the threat that you thought you were facing, what would they do and what would be reasonable? And the test is, the action has to be reasonable, necessary and proportionate. But you'll notice that doesn't say minimal force. Reasonable force isn't necessarily minimal force, okay? Also, the courts do recognise that, when something like this happens, oftentimes you have to make a split-second decision, okay? And also, it's a scary situation. To quote Oliver Wendell Holmes, no man is totally rational in the face of an upturned knife. So that is recognised. What's the best evidence as to what you thought was reasonable? Well, they actually look at your own actions and they say that the best evidence for what somebody was, thinking and what they did is, what did they instinctively do in that moment? Now, obviously, some threats you might have time to assess the threat and then you'd be held to a slightly higher standard because you've got, more deliberation time. But if it's something that's, happening imminently in front of you, then the law recognises that there's no time to sort of judge niceties or anything like that. Now, in terms of the response, some police forces around the world, they use like a force ladder concept, so basically if somebody's waving a fist at you, then you can respond with a knife. If they pull a knife, you can pull a gun. If they pull a gun, well, I'm not quite sure, call in the Air Force. But that's how it is. But we often say in self-defence, it's not what you do that gets you into trouble, it's what you say afterwards. So you have to be very, very careful. And say, for instance, you're in an incident and, you call the police. You've successfully defended yourself or somebody else. The first thing to do is to make sure the police understand what's going on. So, hello, yes, I've just been attacked, but I've managed to defend myself. I need the police and ambulance here very quickly. I'll be the guy in the grey jeans and the dark blue jumper. I'm standing there. This is particularly important. I know we have a lot of international viewers. If you're somewhere with armed police, make sure that they know you're not the bad guy. Stay on the line. Explain exactly what you're doing. I am stood in this particular position. Say you've managed to disarm somebody. I am holding the weapon. I have managed to take the weapon off them and I am holding them. But keep on the phone and make sure that they are relaying that information to the officers who are attending. Also, if the police do turn up, they don't know what's happened. They know somebody's called the police. So, that is not necessarily the time to start arguing the toss with the police. Learn to be arrested like a gentleman or gentlewoman. Just go, okay, I understand what you're doing. Show that you are the calm, reasonable, decent person. You can tell your story down at the police station. Now, interestingly, in the military, they have a mandatory 24-hour cooling off period. So if they use, especially, quite serious force. I won't say what it is because of the algorithm. But then they can't be interviewed for 24 hours. And the idea is that gives them time to sort of rationalise their thoughts. Because we have this idea in the law that, a very common cross-examination question, especially years after the event is, you would agree, wouldn't you, that your memory closer in time to the event is better than it is now? And the common answer is obviously, well, yeah. But that's not necessarily the case, especially in traumatic events. You get all these perceptual distortions, memories fragmented, and quite often it only sort of comes back in stages. And the courts do recognise this, although you can't really put expert evidence in about use of force, so you have to be sort of your own expert. So you can say something like, well, it all happened very, very quickly, but then over the next few days it started coming back to me. I mean, memory is reconstruction, not recall, and that's something we take into account. But quite often it'll be something like, a triggering event. I heard a car backfire and it suddenly remembered everything about them pulling the gun on me or something like that. So yeah, think about what you're going to say. I mean, you could just say, look, I'm still in shock, I'm still traumatized, I'm not ready to be interviewed now. You can try it like that. Do you lawyer up? I mean, people always say, oh, lawyering up is the sign of a guilty person, but not necessarily. And you have to be very careful with use of force because you have used force. Now, it is an element of all offences of like assault, ABH, GBH, all the way up to, lethal force, that the force used has to be unlawful. That is one of the elements that the prosecution have to prove. And they have to prove that to the requisite standard. You don't have to prove a thing. Once you've raised self-defence, it's for the Crown to disprove it to the so that you are sure standard. Okay, so the onus is on the prosecution, but you need to start laying the groundwork, very early. So say things like, if, for instance, you have any training in threat assessment or sort of, body language or anything like that, you can say, from my training or from my experience, I recognise that this person was in a threatening posture, especially if you have to use preemptive force. Things like, well, while he was yelling at me, I wasn't too bothered, but then I noticed he went quiet and his face got red and his muscles tensed. I mean, that's often a sign that somebody is about to inflict violence on you. So you can say, and I recognise that as a sign that a threat was imminent, and that's why I reacted when I did. So that's the sort of thing you need to remember. But we'll cover this in more depth as we go on, but I think that is the starting position. So remember, two-part test, part subjective, part objective. What did you honestly believe the threat to be, and reasonably believe the threat to be if it's civil or disciplinary proceedings? And then what would your average reasonable person do in the face of that threat?